afternoon, ladies and gentlemen. Welcome to Beat Up to Legal World's Saturday Solution segment, where we speak with experts on hot legal topics and latest legal developments. And today, we are discussing the data privacy framework of India and some other major jurisdictions, knowing which can help companies that collect and store data mitigate their risks, as data protection law may have wide ramifications for industries that rely on the collection and processing of individuals' data. So let's find out some key impact points for these players from our experts. To make this happen, we are joined by Prashant Phillips, partner Lakshmikumaran and Sridharan attorneys. Prashant advises clients in cyber law with focus on data protection and data privacy. His experience also includes patent preparations, prosecution, litigation, and industrial design practice at LNS. He has advised clients on issues pertaining to data protection and data privacy, both under the Information Technology Act 2000 and the Draft Personal Data Protection Bill 2018 pending before the Indian Parliament. His technical expertise enables him to fully understand the nuances of an IT system and ascertain the key issues that may give rise to obligations under the various laws. His advisory has been focused on taking preemptive measures to mitigate any exposure from the existing laws. We also have Udit Mendiratta, partner, Argus Partners with us. Udit is a corporate and commercial disputes lawyer with extensive experience in advising and representing a vast cross-section of Indian and other multinational clients. In representing clients from across the infrastructure, hospitality, real estate, renewable energy, oil and gas, fintech, social media, and other domains, Udit regularly appears before the Supreme Court, Delhi, Bombay, and other high courts, arbitral tribunals in both ad hoc and institutional arbitrations, as well as company courts across the country. An alumnus of Amity Law School, New Delhi, Udit has formerly worked at Karanjawala and Company, Trilegal, and Shardul Amateur Madras. We also have with us Nakul Batra, Associate Partner, DSK Legal. Nakul is a corporate, commercial, and transactional lawyer and is part of the General Corporate Practice Group in the firm's New Delhi office. Nakul is also a computer science engineer and has worked with one of India's major IT giants as a software developer. Having earned a bachelor's degree in technology and being a corporate lawyer, he brings on the table a blend of understanding in technology and legal expertise for his clients. His practice mainly consists of acting for companies, promoters, investors, corporate clients on a wide range of domestic and cross-border transactions and rendering legal advice on day-to-day corporate matters and matters in relation to intellectual property law. And I, Ashima, Ohri, Managing Editor of BW Legal World, have the honor of moderating this August session. Experts, once again, a very warm welcome to all of you and to our audiences joining us across various platforms. Let's dive right into the conversation with opening comments from our panelists. So panelists, let me begin by asking, why is data protection important? What far-reaching consequences have data breaches led to in your experiences? We'll start with Nakul. Batra, Nakul, your opening comments, please.
So, thanks Ashima for having me around. Thanks to the other panelists for being part of the discussion around. Back in 2011, when India came up with its first set of rules on the data privacy, which are called SPDI rules, we never thought so that data would become one of the largest business churners across the world. I mean, it's a revolution in the form of an internet, which began in late 80s, and we never thought so that data would become one of the commodities which will highly be tradable and would be valued more than anything else in this world. While we happened to use Gmail back in early 2000s, it was free. You never thought so. Why was it free? I mean, there are no free lunches in this world. So yeah, they were taking your data to actually generate this big tech giants, and you see Google, Facebook, Microsoft, the expanse and the scope of these big techs. I mean, they're bigger than some of the nations in the world right now, just because, they collect your data and process your data, and God knows how much they more can do with your data now. Since it has become such essential commodity, more than valued more than gold or any other security in the world, there has to be some checks and balances which everyone collecting, processing, or transferring this data has to maintain. And that's where we see that, starting with the European Union back in 2018, and they discussed the GDPR for like quite some time. starting from 2012 till 2008, 17, 8, 16. It was a long time they deliberated upon how data should be collected, how it should be regulated, and we are seeing, India, US, China also coming up with data protection laws, how to deal with data. And that's the way forward. That's the era we are talking about. Why data is so important. Those were my initial remarks on why data protection and data security is important in the current age we live in.
Absolutely. Thank you so much, Nakul. Prashant, over to you for your comments, please.
Thank you very much, Nakul, for providing the brief initial insights. What I wish to add, at least in terms of what Nakul has very nicely elaborated in terms of the historical development, particularly in relation to the legal frameworks pertaining to data. So there are actually two concepts, and I would like to just touch upon those two concepts similarly. So the first is data privacy, and then there is data protection. So many a times people, in fact, use these terms interchangeably, but there is a very subtle difference in terms of what data privacy is and what data protection actually involves. So data privacy is actually a concept in terms of providing a balance as to how data can in fact be utilized and provided. And when I say a balance, it is sort of trying to maintain a balance in terms of the rights and the privileges of the individuals with whom the data in fact relates to, and also tries to preserve some degree of interest of the organizations who may be using that data. Definitely, there are certain giants in this world who use and often misuse data, but there are a lot of honest and earnest businesses which utilize data to provide the best possible benefits to the individuals. So data privacy and certain legislations around data privacy tries to maintain a balance in terms of preserving rights of the individuals, as well as keeping in mind the business interests which are of the organizations which are providing digital services to the individuals. Then we come to data protection, and obviously when we have another entity holding volumes and volumes of data of individuals, protection of that data becomes extremely important. And this data protection actually has to be done at a very, I would say at a fundamental level, primarily because of the risks that are actually involved in case if there is any breach of such data storage facilities which are maintaining or storing data. So why is data protection important? Primarily because, and the answer to that is actually twofold. The data protection is actually important because of the nature of the data which is being protected. And the nature of the data itself, and this is something I think so we will also discuss during the course of our discussion this afternoon, that there are broadly two types of data. We are looking at personal data, and we will be discussing on those aspects in detail as we go further in this webinar. And we also have non-personal or business data, or data which is not seemingly personal data. And each one of them actually have its own set of importance, have its own set of implications if there is any breach of such data actually happens. Like for example, if you're talking about personal data, the impact which actually happens will cause a certain harm to the individuals with whom the data in fact relates to. If there is financial data involved, obviously there is an immediate monetary harm that may actually come. Parents actually would want to keep their children safe. So even children's data, if it is actually breached, may result in certain inadvertent harm befalling on children as such. We have medical data, we have lifestyle data, which in fact reserves certain degree of privacy. When I say privacy, that means the privacy in terms of the domain of the individuals themselves. So data protection is important to safeguard these interests. When I say these interests, that means the individual interests at hand. Data protection is also very important when you're looking at organizations, when you have their business data, the non-personal data about it, trade secrets, and all such information which is essential and critical to the business operations of an organization. And obviously, breach of such information would impact the operations of those businesses, and definitely will erode whatever positive developments that they may have in fact developed over the past decades or even over the past few years. So therefore, I would say that data protection is important not only to protect the interests of the individuals, particularly when personal data is involved, but it is also equally important in preserving the business operations or the business standing of an organization within a market, especially when non-personal data or their business data is actually involved. So that is right now my initial input to the question as to why data protection is in fact important.
Very well said, Prashant. Thank you so much. Udit, over to you, please.
Thanks, Ashima. Thank you for having me on this panel this afternoon. I think my fellow panelists have quite extensively sort of, articulated why data protection is important. I think what I'd like to add here is where we are today. We are in 2021, where, every aspect of our life, we're becoming an increasingly, we are in an increasingly digital world. Every aspect of our life is infiltrated by technology. From ordering food to getting from point A to point B, to getting chores done, like getting our vegetables picked up or our groceries picked up. Everything involves for us using app, and the pandemic has only pushed us further in that direction, right? With that obviously comes the accumulation of data, and now with processing power going up by the day, there's just potential for collection of so much data. And to the point what Nakul mentioned, that back in early 2000s, when maybe Google came about and or Gmail came about, and we never thought about why this service is free. For the convenience of using these services, we as consumers fork over more and more of our own data, right? Simple things like even our name, phone numbers, addresses are now available. This data, this data is obviously stored in servers of individual companies. Every interaction that we have online, whether it's on an app or on a web page, this data gets collected and stored. Ultimately, this data which is sensitive to an individual, which can identify an individual, has the potential of being leaked, has the potential of being misused. And therefore, in 2021, I'd say data protection is perhaps an important aspect that legal regimes are trying to catch up to. GDPR, of course, being the first, comprehensive legislation around the subject. We, of course, in India have had SPDI, but it's limited in its scope. We are trying to now model ourselves under the new PDP bill in lines with the GDPR. There are other jurisdictions that are coming up with it. Why it becomes essentially very important for businesses today is because any business, right, typically having a presence online, or even the one that doesn't, can be categorized as a data fiduciary or a data controller, because you are collecting some amounts of data. So you need to be compliant with certain set of rules, certain set of regulations to ensure that you are sort of above board. This is not just true for the jurisdiction that you as a business are incorporated in, but if you're operating in other jurisdictions, you need to be compliant with their set of laws as well. So increasingly, businesses are realizing the importance of making sure that they're compliant with different legal regimes around the world, and data protection being a hot button topic which is being discussed around the world. So yeah, those are my opening remarks. Thank you.
Thank you, Udit. Thank you so much, panelists, for putting that into context. And of course, data is the new oil, and we need to kind of preserve it as much as we can. Privacy is important. Now, moving on to some more pointed questions. Prashant, I'll come to you first. Could we know from you what rules and acts govern the current data protection regime in the country?
As of now, like Udit had just briefly touched upon, we have a privacy legislation in place, although it is not as exhaustive, neither it is as extensive in terms of when you talk about its intended purpose for data privacy. So under the Information Technology Act, we have a certain provision which sort of obligates, or which sort of puts certain obligations on organizations in terms of preserving personal data whenever they are handling information pertaining to a certain individual. And if such information actually is subject to breach, if that information is breached and there is unauthorized access or use of that information, then that violation is sort of precipitates into determining whether the obligations or whether the organization who was handling that personal information was in fact negligent in ensuring certain security procedures in retaining that information. And that is where the SPDI rules, the sensitive personal data information, and it's a very long name, but that is where the SPDI rules actually come in. As such, the Information Technology Act, and it's a very strange kind of I would say a framework, because the legislation around data privacy is not featuring in the primary legislation. It's actually there in the supporting rules. And the rules provide certain obligations which an organization is supposed to discharge while they're handling personal data. And strangely, and this is a distinction which I think so my fellow panelists would be focusing upon, that they don't identify the obligations as an active obligation. It's more a reactive obligation that only comes into focus once a breach actually happens. So what exactly are those obligations? The first and foremost being what is called a notice requirement. Organizations are required under the SPDI rules, and mind you, again, not under the Information Technology Act, but under the rules, they are required to inform the individuals that their data is in fact being collected, and they are also required to inform the purpose for which the data is in fact being collected for. Similar kind of principles are also there under the proposed legislation, but I would say that the granularity in terms of which these requirements are supposed to be discharged is notably absent, and that's the reason why this legislation or this rule does not effectively ensure protection of personal data or privacy of personal data. Then once the notice requirements are actually taken care of, there are certain other requirements which have to be discharged depending upon the nature of the data which is being handled. So we have data which is personal data per se, and then we have another category of personal data called sensitive personal data. Personal data is defined under the SPDI rules as any information which will be, which is capable of establishing the identity of an individual. But unfortunately, there is no specific definition of sensitive personal data. It only outlines certain examples in terms of what such sensitive personal data could in fact be. And now coming to the obligations part of it, there are certain obligations which are required to be discharged if an organization is handling sensitive personal data as opposed to only personal data. The first being that the data, if it is sensitive personal data, can only be obtained by a consent. Now, consent is also something which is figuring out under the PDP bill. However, the granularity or the extent to which the consent has to be captured is again missing. So when we're talking about consent being obtained, that consent could actually be obtained through just a click-crack kind of a mechanism, wherein a single checkbox could actually be used as the basis for obtaining consent for a number of different purposes which an organization may convey or may try to convey to an individual. So that is something which, while we are discussing the PDP bill, is not the case anymore. So, those are the deficiencies which I believe had in fact been discussed by the Supreme Court in their pro forma judgment, and which have been addressed to a certain level, to a certain degree under the PDP bill as well. And once the consent is actually there, we are talking about different stages in which the data is being processed or being collected or being maintained. So the notice requirement and the consent basically cater to or address the collection phase. Then we have the use or the processing phase or the storage phase. There are certain requirements that the processing is supposed to be done or the use is supposed to be done according to the purpose based on which the consent or based on which the information was in fact being collected. Again, there is no qualifier in terms of what exactly should the purpose be, whether it can be broad or whether it should be specific. These kind of aspects are completely missing from the SPDI rules. Then coming to the storage part of it, there is a restriction or a requirement that the storage should be only essential to the extent that it is required for the intended purpose, and it should not be in fact for more than the time required for which the data is being processed. That is also something which is only mentioned, but again not properly described or articulated in terms of providing the organization sufficient information as to where what exactly is the line which an organization or in terms of business practices have to implement in order to be compliant. And then we have sharing and cross-border transfer as well. Those are again contingent on whether the sharing with third parties or sharing with other countries outside India, is it tied to the purpose or is it something which was contractually agreed upon with the parties involved? And cross-border transfer again is something which is permitted, but again, the organizations have to ensure that the entity or the country to the jurisdiction where the data is in fact being ported ensures the minimum level of protection, which is also equivalent to what is in fact guaranteed under the SPDI rules as well. So that sort of sums up the entire framework in as brief as possible manner that I could actually manage as well. So that is what it is. But there are different deficiencies. It is again it is not very exhaustive. It does not at a granular level point out what exactly needs to be done to adhere to these different obligations, which I believe have now been addressed by the PDP bill. And there are certain amendments which are being proposed. We will see how the PDP bill eventually gets passed. But those deficiencies have in fact been addressed to a great extent by the PDP bill.
Absolutely, Prashant. So clearly, at the moment, we do not have a robust legislation to take care of this. And I'd like to share a stat here: the 28% Indian Android apps can read your SMS as compared to 3% US apps and 0% European apps. Now, in light of this data, Prashant, on a scale of 1 to 10, how would you tend denoting, of course, the monumental change that PDP is likely to bring? How how do you see this change coming about, and what is the new regulatory framework going to bring for India in view of our current sensitivity to the election?
Okay. So I'll address this question first. That in terms of sensitivity, yes, business will have to comply with the obligations under the TDP bill, primarily because there are huge fines involved. And the fines, I believe that the organization is sensitive in terms of themselves as responsible businesses who will respect and protect the personal data of individuals. Now, coming to the monumental change, I would say that on a scale of 1 to 10, it is definitely a profound legislation. When we look at the source of this legislation, now we'll have to see that this legislation was not thought of by the Parliament on its own. The Supreme Court, in fact, guaranteed and recognized the right to privacy as a fundamental right, which necessitated and which, in fact, which required such kind of a legislation to, in fact, be proposed. So, the recognition of an aspect as a fundamental right led to the creation of this legislation, which I believe is the sole governing criteria to call this legislation a monumental in itself. The second is also very important. Why? Because typically, when we're talking about fundamental rights, all the protection about fundamental rights is typically directed against states. So, if there is, in fact, any encroachment by states on fundamental rights, then different legislation provide different remedies, which are in fact available both under specific legislation as well as under certain civil legislation as well. But here it is remarkable because individuals will also have an opportunity, or also have a mechanism to fall back on to exercise their rights against private players. And that is again another testament or another point which speaks towards the importance as well as to the fundamental nature of this legislation. And obviously, at the same time, the third point which I would like to say, or at least point out, is that at the time of ensuring different checks and balances, which will ensure the protection of personal information, different rights are being provided to individuals. The legislation also provides the opportunity to use personal data, to process personal data. And obviously, there are certain obligations which they necessarily have to discharge before they can do that. So unlike certain misconceptions that are actually there, that privacy legislation prohibits processing by big companies, in the case, it in fact allows it, provided you fulfill certain obligations. Obviously, the use or the extent to which personal data can in fact be processed as rampant as one would in fact allow, there are certain checks and balances which the legislation actually proposes. So the third point, which again I would like to sum up, is that the monumental nature of this legislation also comes forth because of the balance that this legislation tries to strike between the rights of the individual as well as try to preserve business interests of organizations, particularly when you are providing digital services. So we can definitely avail the conveniences of this digital age without worrying about how our personal data is.
Absolutely. Thank you so much, Prashant. And on that positive note of maintaining checks and balances, Nakul, opening the floor to you to understand what are these companies doing right or wrong? What are some of the strict obligations on companies and data collectors in India, and under the impending bill, like Prashant mentioned, there is a balance being struck by the legislation. So your thoughts, please.
Thanks, Prashant, for setting the context and the tone of the new data protection bill. And I hope it comes soon. It's been there for long enough, but not seeing any step in the positive direction. But yeah, anyways, the first question is what is the India INC doing wrong or right. I believe they're all doing it all the right way. I mean, there's nothing which stops them from collecting rampantly personal data. So everything in the interest of business being done is done in the right way. As you see, the SPDI rules of 2011, that's under 43A of the Information Technology Act, that's the only legislation, not even legislation, it's an executive framework we have as of now, and it does not even asks you for a consent while you take personal information, now personal form of name, address, phone number, which are capable of recognizing an individual. You don't need to have a consent, but you need to have a privacy policy in place. The consent obligation is just for collection of sensitive personal information. So the industry is doing nothing wrong. It's just that we have a lack of regulation in which the businesses are growing, and that's a cause of concern in the coming months also, while the PDP will be promulgated into a new law. The concern here is that retrospectively the consents which have been given under the previous regime, in the SPDI regime, they are required to be renewed, and large businesses may hit a big setback in terms of performance and delivering services and products to the customers, as all consents have to be renewed, taken explicitly. And so our PDP bill and the other regimes in the world are all based on consent as one of the frameworks for privacy. So you need to give consent as from an individual to begin with. Now, just to take a step ahead and detail out how the consent and what kind of consent is required, is that consent has to be free, informed, specific, clear, and capable of being withdrawn. You attach so many checks and balances to the very item called consent. If you start looking at the services and the apps you use, the data, the personal information you give to big techs and to everybody while you deal in digital world, I don't even remember how many times have I clicked on the button, okay, I agree. Not as of now, but later when the law comes in, everything around me is so digital that I would not even remember how many times would I have given a consent to someone to collect my personal information or sensitive personal information, which is what we called as consent fatigue. Every now and then I have to give consent, and I don't keep track of it. So there are consent managers, the concept of consent managers, which have been introduced in the form of the bill, but I don't know how will that work, because the DPA has to come, the Data Protection Authority has to come and put out its thought on how the consent managers for an organization will work or not. What I believe is that a better way to do it would be a centralized repository for all my consents, where if taking a clue from the new TRI regulations, the UCC regulations, where the entire consent for commercial communications has been done on a blockchain. You see all the consents which you have given to any specific entity for getting to you for commercial communications is there on the web at one single platform. That's I believe a way can be. I don't know how difficult or easy will it be to implement it, but consent from me as an individual, if it can be recorded at one place and I have the right to withdraw, delete every consent of mine under one single head, I believe that's something which can be a game changer. Additionally, if you talk about the coming in regulation and its applicability on the businesses as they are doing it today, things will change drastically, because as of now we see the entire regime, the entire focus is on consent and nothing more. Once you take consent, you can do everything and anything. But in the new regime, you have to ensure that whatever you collect as in the form of a personal information or SPDI or taking a step ahead in the form of a critical and sensitive personal information, children's data, you will have to ensure that the purpose for it is collected is the only purpose. There is a reasonable and fair amount of processing and no more than what it is actually required to give and deliver services. there is obviously an obligation towards the quality of data which you collect. I mean, you process. The processing is required to be complete, accurate, and not misleading. So that's one additional point is that, safety, security, safeguards in order to protect any breaches is also one of the components which, as of now, most companies take ISO 27001 as that's the benchmark for anybody to have, reasonable security practices in place. But that's not going to happen anymore. We are in a regime where we are, following GDPR, and the security and safeguard standards which are there in the GDPR is almost similar under the PDP bill, and in the form of audits and impact assessments of how you collect data and what will be the impact on the data which you collect. Last but not the least, we have a stringent requirement of data localization, and it has just not come in the form of PDP bill. Previously also, India is very, very, so India is actually the powerhouse to the entire world when it comes to outsourcing BPO industries. So what we have right now is the power of data, and we don't want to get that out of our hands very easily. That's our goal, the new goal. And therefore, this nationalization on the data localization thing is going on. That we keep the nation's data within India and do not transfer it. And if you look at it from RBI perspective or an insurance IRDA perspective, time and again, RBI has reiterated, and we have to keep payments related data. Transactions related data can go overseas, but payment related data has to stay in India. Insurance related data has to stay in India. Certain kinds of defense data also is required to be in India, whether you are giving it, whether the services are being given from outside India. So that's data localization, which is a little stringent under the PDP bill, and I believe it's the way forward to go, because we as the participants, India as a participant in the overall world economy, has something which is data is of extreme importance to us. That's what my thoughts are on what the entities are doing right and wrong, and what's the way forward for these guys.
Thank you, Nakul. And like you mentioned, consent fatigue, I have a stat in that over 90% edutech and webinar apps access your camera, 40% OTT apps can record your audio. So that's the level of invasion, we have from all of these sort of apps and websites. Now, what happens when coming to the rights of consumers and those who are sharing these data, the data principle, privacy being a fundamental right. Now, what are people's rights when there is improper disclosure of personal information?
Time and again, we have seen various news about big data breaches from cloud servers, Amazon S3 buckets. I could think of an example of Air India, where entire 16 million users' data was lost and was up on the dark web for sale. Similarly, in the case of the Indian Railways also lost data from IRCTC. Dr. Lal Path Labs also lost a lot of personal information. Even the nature of tests you had undergone was out, was accessible. I don't know whether they were. It was accessible by some ethical hacker and was informed. But such data breach incidences are very common now. Now, under the current regime, if you see, the only way to look at it is that there are penalties in the form under 43A of the Information Technology Act, which is mostly in the form of compensation for loss caused. But there are no punitive damages kind of a thing which the law recognizes as of now. As in what GDPR and the PDP bill says is that huge amount of penalties are there to compensate for your loss. But if you see, I don't see any case or occurrence in the market where courts have granted in a class action suit for 20 million users who have lost their data, because you are not able to showcase that there has been an actual loss to you. That regime is going to change. You will have to pay for the loss to the data if you have not been strict about your security standards. That's one big shift from the current one to the new one. Yeah, that's my thought on damages versus compensation in the current and the older regime. I mean the coming regime.
Thank you, Nakul. Thank you so much for adding that bit. And over to Udit now. Udit, we've understood how domestic legislation is likely to make things better, but is there further room for improvement? So maybe we can take that from the GDPR and other global regimes and their impact on companies having businesses in these locations, or data being collected from these locations. So over to you to shine some light on that.
Ashima, I think here this is not a set of laws that are just domestic. Now, if you see the GDPR or if you see the proposed PDP bill, both of them have extraterritorial application, right? So what that means is that if there's a company that is in India but is offering some sort of services to, let's say, citizens of the European Union in different countries or China, etc., have to necessarily comply with the European Union's law as well, right? Now, whether you see our proposed PDP bill, the GDPR, or the PIPL, which is the Personal Information Protection Law in China, which is coming in November, all of them seem to have one common factor being consent, as Nakul mentioned. Nakul also mentioned free, informed consent, right? Now, what that then makes very important for businesses, companies having an online presence, offering their services virtually, to do is to frame a privacy policy which is ironclad, right? Which covers requirements under different jurisdictions, different set of information laws that apply to them. Now, in doing so, you will then be able to at least demonstrate that I have my user's consent, which is to these set of, what I've put down in my privacy policy. Having said that, I think it's easier said than done, because each jurisdiction will have its own nuances, will have its own sort of departures from what. There is obviously some commonality among all these, and I'd say that whether it's the Chinese law which is coming up or the proposed Indian law, it's all modeled on the GDPR. Even the Californian law, the California Privacy Rights Act, which came, even that is modeling itself on GDPR. So yes, there's some commonality, but it's not as easy or straitjacket, to just put something down and you have, you sort of like are above board in each jurisdiction. That's one. What I feel is, perhaps the way forward, unlikely to my mind anytime soon, given the geopolitical environment that we are in, is to have some sort of a global regime around this, right? We have, let's say, the ancestral law, right? Recognition of arbitration awards that emanate from different jurisdictions, enforcement of these awards in different jurisdictions, right? Now, in India, we'll recognize awards coming from Singapore. Our courts will execute those awards, vice versa. A lot of it also depends on reciprocity. We have a similar regime for, let's say, intellectual property, right? Where intellectual property rights emanating from different jurisdictions are recognized under, let's say, UN conventions in different jurisdictions. I think there is a need here for something similar to come, and I'm not saying it's coming anytime soon, but I think that would be the way forward, given how different countries, different trading partners, and we live in an increasingly global, connected world, right? And it's impossible to sort of just pull back and have only our laws applied to us. It doesn't work in isolation like that. To talk a little bit more specifically of what I talked about, the divergence in different sets of laws. Now, the law that has been passed in California mandates that a company that is offering its services to the residents of California, we're not even talking about the US, we're only talking about one state. We may have 50 different states passing 50 different sets of legislation in the US alone, and of course, every other country. It says that you must have an option on your website which gives an opt-in, opt-out kind of process to the user that says, do not sell or share my personal information. It also mandates you to say, limit the use of my personal information. So if the user checks one of these boxes, the company that is collecting data on that individual who's a resident of California must ensure that his data is precluded from the bigger set of data right? So I think if we continue down this path where we, of course, each company having, let's say, a global footprint or even footprint in a few jurisdictions would have to comply with different sets of regulations, different sets of regimes, it's going to become increasingly complicated. There isn't going to be a one-size-fits-all kind of formula that companies can adopt and move forward. I think one of the principles that we must keep in mind is that we need to ensure, yes, data protection is extremely important, but what is also important is to facilitate business. So in order to facilitate business, we need to ensure that there is some sort of a global, commitment to respecting or having at least commonality of some, privacy regulation that applies universally to everybody. If you see China's the personal information protection law, it keeps saying that China is committed. It sort of has that flavor in it built into it that China is committed to respect and operate within a global framework when it comes to protection of personal information. I think it's also lip service. I understand that, but I think that's the way forward. Because in the absence of some sort of global consensus on issues surrounding personal information, sensitive personal information, I think we're going to have a situation where businesses find it increasingly difficult to adapt and model themselves to be compliant with regimes across the world.
Absolutely, Udit. So, you mentioned all these GDPR, CCPA, and the China's personal PIP law. Now, if you could understand with help of an example, somebody who is based in India, having businesses in these locations, or for any reason collecting data from these locations, what would be your sort of advice directly to them? What are the 3 steps they need to take to kind of, in this complicated network of legislation that we have across the globe? Now, how do you really even go about addressing, what you're sort of flouting in what jurisdiction?
So, Ashra, what I would say is that, let's say there's an Indian company. Let's take the example of an Indian company providing services to consumers in India, as well as, let's say, the European Union and the US, let's say specifically California. What I would suggest is that, given where we are today, the company needs to ensure that a different privacy policy applies to each one of their consumers, depending on the jurisdiction that they reside in, right? So that this particular privacy policy that they sign up to, the individual user or the data principal signs up to, is compliant with the law that applies to his jurisdiction, right? This would then ensure that, for each individual who is giving consent, his consent is as per the regime that applies. The information which is sought to be put within the privacy policy that applies covers the compliances or the requirements under that regime. I think that would be step 1. I think it would even have implications in terms of processing of data. Now, the definition of, let's say, personal information, of sensitive personal information, may differ from jurisdiction to jurisdiction. And you'll have to ensure that whatever information you're collecting is clearly spelled out in your privacy policy. Again, depending on different jurisdictions, applying to different consumers that an organization or a company is catering to make sure that they know that this is the information being collected in respect of me, and this is how it's being used. This is who it's being shared with. This is where the information is being stored, because each, like Nakul mentioned, there is this increased push towards localization of data. We're pushing for that in India. The Chinese law does that as well. So, the user essentially needs to be informed of each one of these aspects, which can only be done through individual privacy policies and taking consent specifically as required under the set of rules or regulations that apply to each jurisdiction.
Absolutely. Thank you, Udit. Coming to Prashant. Prashant, what are your thoughts on this? And if, you could also help us bring best practice into picture, what would be your, 2 points or 2 cents on how this complicated rigmarole of data privacy and protection legislation, across the world can be sort of simplified? Because, like we say, theoretically, we all know what the law is, or, compliances are. But when we actually go out, we are, like Nakul mentioned, in this consent fatigue. We have so many places that would ask for permissions and that we have to mindlessly kind of give in to, because otherwise you can't use the app at all. Now, for all of these things, what should the companies really be doing in light of not just the domestic legislation which is coming, but globally? You're supposed to be able to compete globally at at the business level. Your thoughts, please.
Thank you very much. So in terms of, there are two aspects to it again, or in fact, there are multiple aspects to it. So I think so that one of the profound impacts that this legislation will actually have, it will force, or at least I would not say force, but it will encourage companies to understand and also to evaluate how they are processing personal data. In many circumstances, as both Nakul and Udit had outlined, and many a times certain permissions or certain information is actually not required. So perhaps certain of this in fact the statistics that you had shared yesterday, we see that Google has in fact improved its usage of personal data. When I say improved, that means they've reduced their reliance on personal information which is being collected through their devices. So I think so that such kind of legislation would in fact encourage companies and businesses to understand and evaluate whether the personal data that they are currently collecting, do they in fact need it? Because many a times collection of data, it does not come in the sense, it does come with certain encumbrances as well. You do require infrastructure to store data, you do require infrastructure to protect data, and obviously you require technology to analyze and process data. So all of these considerations, I would say that this legislation would in fact encourage businesses to understand and evaluate how they are in fact processing personal data. The other thing which I also see is that it will also enable, the consent fatigue is definitely an important issue, but that is something that I have personally experienced business organizations adapting around it. They have devised novel ways of presenting and designing the user interface which minimizes the amount of consent checks that are actually required. And definitely it ties down to the purpose for which they're also collecting information. When we are looking at an app like Facebook, I'm sorry, Facebook is an often misused and an abused example, but the extent of processing that Facebook actually undertakes would be very different from the extent of processing that perhaps Maruti would in fact be undertaking. So obviously, when the extent of processing changes, the obligations would also change, and the consent requirement would also, would also get more relaxed. When I say more relaxed, that means you perhaps don't require consent for those many number of data points. You don't require consent for a number of different purposes for which you may end up using the personal information for. And definitely, I've seen businesses changing their UIs so as to minimize the extent or the, I would say that the frustration which a user may in fact experience while providing their consent. Many a times you have different features which are being provided through these apps. And whenever such features are in fact being provided, such kind of consent mechanisms could be made available to the user at such stages. So these are just basically some of the initial thoughts, at least, that I've seen that I would like to share. And some of the points which I've actually observed, businesses adapting to such kind of constraints. And whatever challenges that we are right now discussing, that, okay, this is going to involve a pan-geographic location kind of a compliances, companies are in fact used to such kind of compliances. There are tax requirements which are varying and different across different jurisdictions. Companies do comply with those tax requirements because of the penal provisions that are actually involved. But those are not the only determining or the driving factors behind these organizations complying. They want their businesses to run smoothly. So I believe that this is just going to be another compliance requirement which the organizations may have to undertake, considering different obligations which different legislations may in fact impose on those businesses. So it is something that we may again have to take it, the businesses may have to take it in their stride and design their business operations around it. I also see that a lot of formalization of business operations would actually happen as a result of this legislation. What do I actually mean by formalization? If you look at different financial institutions, a lot of personal data is in fact shared between members of the same organizations very informally, like through WhatsApp or just by clicking photographs of documents and then sharing it with people. So I believe that at least this legislation would enable formalization of data processing or data utilizations within businesses, which will again, I would say, contribute to the data security aspect of it. The lesser chances of people, sharing data freely or informally, the lesser would be the possibility of data breaches actually happening. And data breaches typically happen not many a times as a result of negligence by the organizations. Despite the best possible security measures, data breaches have been known to actually occur. But again, the data privacy legislation does not intend to penalize organizations who have suffered a data breach. It only tries to enable the organizations, implement certain obligations or implement certain checks and balances which will ensure both security as well as privacy of the personal information which is shared, which is in fact being stored by them.
Thank you, Prashant. So yeah, better formalization of sharing of data. Coming to you, Nakul, the new proposed law is probably going to take under its ambit not just the online businesses but offline businesses. Now, your 2 cents on what are the best practices that they could, from the legal perspective, of course, they could be looking at or should be looking at.
As and how the process of collection, storage, and retention of personal information is outlined under the new PDP bill. It will apply the yardstick of the measurement on compliances for offline and online would not substantially change. Although that is not the situation as on date. I mean, if you have something written on a piece of paper, it doesn't apply because SPDI rules are primarily applied to digital form of data collection. So if you are in a business which is purely offline, the SPDI rules, God bless you, doesn't apply to you. So do whatever you want. But having said that, the offline businesses will now also have to follow, and more with digitalization. I don't think so there is any organized business which purely runs on an offline model as of now. So at least 99% of all organized businesses as of now have their one leg into the digital world. So the transition would not be that difficult. The transition would be difficult if you see in the unorganized sector, which also purely works on the kirana stores. Let's, for example, if they collect information, the small clinics, doctors, they also collect a lot of information in their registers and books of account and other books. Those things have to be seen from a very different angle as to how would you apply, what would be the yardsticks to apply it on an individual or a small entity which collects personal information. But it's all going to take some time, with a lot of jurisprudence coming from a little more developed nations and little more developed regimes like GDPR, which effectively also took a lot of deliberation for 5-6 years until they have had a GDPR in 2018. We are also going to take some time. Definitely, we anyways. The law it always takes it always has to follow technology. So we're going to definitely take some time to reach that stage. And one more critical item which I also see is this transfer of data from India to other jurisdictions. I mean, we've all seen that. The applicability of data adequacy, the protective adequacy we need to have arising from the Schrems II judgment, where Facebook was effectively transferring everything from European Union to its headquarters, from Ireland to outside to the US. And we've seen last year that the protective commercial clauses and the privacy shields, which the US used to call it, so has all been negated by the last Schrems II judgment. So that's also one big change we'll have to see. While India has to transfer its data overseas, we'll have to look at other jurisdictions, whether do they have same set of protective measures applied while the Indian data is being transferred. One missing part, I believe, from the data protection law is that someone accessing so while from India you access data from EU or EU nationals, data is being processed, everything under the GDPR applies. While the extraterritorial nature of the PDP bill stands, so there is still a doubt that while someone in the US processing or taking data from an Indian citizen, what will be the yardstick to for compliance and for processing and transfer and storage of such data. So everything from domestic till to the extent of transferring of that data overseas, it's all under process and will take some time and some kind of legal jurisprudence behind that to come into better picture for us.
Thanks, Nakul. And bringing in Udit on that point, Udit, like Nakul mentioned, there's somewhat of a gray area on the aspect of someone collecting an Indian individual's data in extraterritorial jurisdiction of PDP bill. So what are your thoughts on that, and what are the kind of sanctions that one is looking at? If you could, get some examples from you on that.
I think the data protection bill as it currently stands covers entities irrespective of where they're incorporated, and if they're collecting data on Indian citizens or if they're processing data on Indian citizens, they are mandatorily to comply with our set of laws, right? Including this. Now, of course, we're going to see the final form, hopefully in the winter session of Parliament gets tabled this year, of the bill. But of course, that's anybody's guess for now. But to my mind, this aspect is important because in the absence of covering within this law, the entities, just by being incorporated outside of the country, being exempt from our laws, does not give adequate data protection to the citizens of India. It's also not in line with other regimes as we've seen on the GDPR, the PIPL, etc. In terms of sanctions, like I mentioned, I think there absolutely needs to be some sort of global consensus on these issues, because it's going to be difficult for Indian courts, regulators to sanction entities which have no presence in India but are somehow dealing with data under contracts from different Indian entities sitting abroad, right? It's going to be increasingly difficult for us as Indian regulators, courts to sanction those entities, to impose fines on those entities. The same is true vice versa. If there's a court in the European Union that's looking to sanction an Indian incorporated company, it's going to be difficult. It's going to be jurisdictional challenges involved, so on and so forth. And therefore, I truly believe that there needs to be some sort of global framework around these issues, and not individual countries coming up with their own laws. They can be in consonance with one another, and that would help. I think one thing which I would also like to mention, I think this whole push towards data protection, data security is also emanating from individual users being increasingly more and more informed about their rights, more and more informed about the risks that forking over all this data poses to themselves, right? Companies in the wake of these informed users are now looking to project themselves as, at the forefront of the battle against data breaches, at the forefront of data privacy. You'll see Apple modeling itself to say that we have the most secure data practices. You'll see Google following suit, Samsung following suit, etc. I think what is also important, and correct me if I'm wrong, Nakul, Prashant, I think what we ought to see in the legislation that's coming up is, rather than an opt-out feature, that I opt out of my data being shared with third parties, or I opt out at my data being utilized for, let's say, targeted advertisement or creating a profile on me, it should be an opt-in, right? I, as the user, should have to opt in specifically to give consent for these practices and not opt out of them. I think that would go a long way to give control back to the individual users, to the data principals, as to what is it that they would like to, how they would like for their data to be accessed, stored, processed, etc., shared with third parties. And I think that is something as on date that I don't see in the current. Prashant, Nakul, any thoughts on this? I'd love to hear from you guys.
Opening the floor to Nakul and Prashant. Prashant, please, starting with you, your comments on that.
So yes, the PDP bill does in fact have an opt-in mechanism wherein by default all the options are in fact negative, in the sense a user would in fact have to positively select or positively choose an option for certain aspects of personal data to be processed. And in addition to that, there is also an opt-out mechanism wherein if the consent has in fact been provided, the individuals have the right to withdraw their consent and also stop further processing of that personal information. Although this is something which is not absolute in nature, it is contingent on other laws. Like, for example, you cannot choose to withdraw your personal data to be processed from the income tax department. So there is an interplay of what the users can in fact do with their data versus what the law also requires, other laws, not necessarily the PDP bill as well. But that is something which is in fact an addition over the current legislation. The SPDI rules did not specify whether an opt-in or an opt-out mechanism is something that is required from an organization. So as a matter of convenience and as a matter of collecting as much data as possible, perhaps, there was an opt-out mechanism which was in fact being proposed, and by default, all the options would in fact necessarily dictate personal data being processed, but later an individual could in fact opt out of it. So by default, all that information was collected earlier, but now that is going to change under the PDP bill.
Thanks, Prashant. Udit, you wanted to
can I
come in
just
on that?
add? Yeah, Prashant, this I understand that the PDP bill now has this withdrawal of consent concept, right? But oftentimes that withdrawal of consent would come with a user or data principal's inability to use the service as a whole, right? For example, if you do not consent to, let's say, WhatsApp's privacy policy, you as a user cannot use WhatsApp, right? The courts in India have taken, some sort of, a line on this to say that in fact doesn't work. This is, of course, a private contract between an individual and a private entity, but something as fundamental as, let's say, a messaging app telling you that this is my privacy policy, either say yes or stop using my app. That kind of high-handed behavior from these top companies, I think, there needs to be regulators to step in.
Yeah, you're absolutely correct. And this is something which even the PDP bill wants to address. And that is where there are specific provisions which require that you only use or collect information for the purpose for which you are collecting it. And such kind of high-handedness can no longer be exercised because of the purpose limitation requirement under the PDP bill. So I see that those practices, again, the organizations may have to evaluate such practices wherein no longer such high-handedness would be feasible. Like, for example, what is possible now in Europe would perhaps be the same case in India as well when users are using WhatsApp. The kind of privacy policies which are already existing in the EU would see the light of day in India as well. But you are correct, because of the absence of proper legislative framework, nothing much can be done at this stage, which I believe would change once the PDP bill comes into force.
That's anyone's hope. Nakul, your last thoughts on this?
So, as both Prashant and Udit rightly mentioned, that we are grappling with this problem of high-headedness of these apps which we just can't survive without in today's day and world. I believe that it will be a difficult task for us to achieve that end, because it's difficult to bridge the gap between what is necessary and what is a little less necessary for me to provide those services. There is somewhere or the other which these big techs would like to put as a condition that this is most important for us to actually render these services or deliver these services to you. So that will be a cat and mouse game, so to say, in coming days. Just one last bit on clarification of the applicability, the extraterritoriality of the PDP bill. If you look at section 2C of the PDP bill as it currently stands in, it's just not applicable to every set of information and every set of data fiduciary who is located outside India. It's a limited set. It's a limited set where you see that if the Indian data is used for profiling of the data principal who is situated within the territory of India, and by systematic businesses for activities and offering of businesses, only in those particular limited circumstances, extraterritoriality of this act would apply. But in any other case, it's still a lot of gray area where you see collection of data is just not for business and for profiling. There are many other categorizations of data which you collect, store, and process outside India. And there the PDP bill is silent as of now, which is the difference between GDPR and as we see on date. So it's not 100% extraterritorial, and that's one of the matters of concern, and I don't know why is that been left out.
Thank you so much, experts, for shining light on all of those concerns and bringing out these solutions to the table. Thank you so much. I request the attendees, if you have any questions, please put them now, so we can address those and take those to our experts. If not, you can also write to me at ashima@businessworld.in with your questions, and I'll make sure that those questions are put across to our experts. So thank you so much for joining us today, all the participants and panelists. Thank you so much for giving us so much information today. Too much to soak in, and let's hope the PDP bill sorts out most of our concerns. So thank you so much for joining us today.